All right, I'm moving on. Before I move on, I will ask you, does anybody have any questions specifically about warrants?
What about when they won't provide you an affidavit, but they're saying there's something keeping your child from you, basically 5 times until they can lie to gain the warrant?
Yeah, you're going to allege that in your complaint. There will be a specific allegation that says, I demanded to see the supporting affidavit, and they wouldn't give it to me. That's it. Just one, well, you allege it in your complaint.
If you have your child removed, and they don't give you a reason, and they don't have a warrant, how long do they have to get the warrant or to charge you with something?
Okay, the way warrants work, you have to remember that you have a constitutional right to uninterrupted care, custody, and control of your child without undue government interference. What undue government interference means is that you have a right to due process of law before they sever that interest. That means, like for a warrant, for example, they can't legally sever that parent-child interest unless they went first to the court to establish that they needed to sever that relationship to protect the child. So in your circumstance, they don't have any time to get a warrant once they take kid. They blew it. The next question is going to be if a warrant wasn't required. You know, there was, for example, an emergency where the child was going to die or suffer a severe bodily injury in the 2 hours it would take them to get a warrant. Then, by state law, I believe, and I'm not a juvenile dependency attorney, we're hoping to have one here today to answer these types of questions. Yeah, but it's my understanding, and this could be wrong, that they have, I think, 72 hours to file a petition with the juvenile court in order to get the juvenile court to go ahead and rule on the issue. So that there is sort of a stopgap there if they blow the warrant. But that doesn't mean, let me answer this question for you too, even though you didn't ask it. If you're suing them for taking your child, and there was no emergency, they didn't get a warrant, just because the judge later, when they did file their petition, and the judge says, oh yeah, take the kid, that does not obviate your civil rights action for the taking without a warrant. So that survives. The burden, though, is going to be on you to show that up until the point the judge made the decision, first of all, that there was no emergency when they took the child. Secondarily, I would suspect, I don't know the facts of your case, but I would suspect that when they did make the juvenile dependency petition, when they did file it, in their allegations, they probably didn't tell the truth, and they probably did not tell the whole story. They didn't tell the exculpatory facts that would have obviated the emergency. And then they probably signed that thing under penalty of perjury, which I think in all counties is required on the initiating petition, which is really cool, because the moment they sign that thing under penalty of perjury, Costanich goes away. We don't care about Costanich anymore.
Nice.
Because there's pre-existing case law that says that a juvenile dependency petition is the equivalent of a warrant affidavit, and even a prosecutor, when they sign that guy under penalty of perjury, is screwed if it's not true.
Yay! Hours means day, like working hours, or is that just from the 20 they pay you 72 hours later?
72 hours, counting sequentially 1 through 72.
Okay.
Sean,
Yeah.
so if a child is taken without a warrant, do they always have to get the warrant later through a 72-hour process?
It's not going to be a warrant. Because what it's going to be is they'll file a juvenile dependency petition, there will be a detention hearing, and then what they'll do, they'll file with the petition, they will file a detention hearing report. Then there will be a detention hearing where the judge reads and considers thoroughly that massive detention report and makes a ruling in 5 minutes, and rubber stamps, I shouldn't say rubber stamps, does an analysis and makes a decision based on the recommendations of the social worker.
Is that in every case?
Pretty much.
Okay.
Pretty much.
I don't know the process.
Isn't there, I mean, I know mothers and
Yeah,
fathers
wait.
who have they never, they may say they get a warrant, but then they go years in the court and they've never been charged with a crime or accused of a crime.
Yeah, hold on.
Doesn't a warrant?
I'm not beating you up. I'm not beating you up.
Doesn't a warrant presuppose a crime?
No.
Okay.
I'm not beating you up. There's a general statement for everybody. If you're going to ask a question, ask the question. No preparatory statement, just get right to the question.
Okay.
Go ahead.
At the time of the removal, if the children were residents of Tijuana?
Residents of?
Tijuana?
Oh, that's a dicey issue.
You want?
I'm not even, Mexico.
Oh, Mexico.
I'm not even sure that the court would have jurisdiction in that circumstance. So that's something I would say we should talk about later.
What if the child's not at the residence and it's outside the county coming into another county?
I don't know. I would say that's probably similar to her situation, and that's something we should address later.
What about lack of a warrant or consent for public school questions?
Yeah, that's a good issue. There's, the question was, just so that everybody has it, and correct me if I'm wrong on this, but the question was, is a warrant required when a social worker wants to go out to a school without the parent's knowledge or consent and interrogate the child at school? Did I get the question right?
Absolutely.
Yeah.
Okay. There's a recent Ninth Circuit, well, I guess it's not recent anymore, but it's sort of a hot button issue right now. It's a developing area of law. Green v. Camreta is the case. It went all the way up to the U.S. Supreme Court, the Ninth Circuit case out of Oregon. And essentially what happened there is a child abuse investigation. A sheriff with a social worker went to the school, pulled the child out of class, conducted, I think it was a 2-hour interview with the child, and then, the Tennessee case, the criminal case actually ensued. The child sued for that, as did her parents. And what the Ninth Circuit found was that the interrogation of the child at school required a warrant. Okay? And it was a violation of the child's Fourth Amendment rights for the sheriff and the social worker to conduct the interrogation at school. And remember, we have a corollary right in favor of the parents under the 14th Amendment, so there was an issue there as well. The sheriff's department, as I recall, it wasn't the social worker, it was the sheriff that filed the writ of certiorari and went up to the Supreme Court with the issue. Now, the Supreme Court, what they did was sort of funny there, is they did not rule on the warrant requirement. What they did is they vacated the portion of the Ninth Circuit's opinion that dealt with the Fourth Amendment issue and essentially said, because of the procedural posture of this case, it's really moot. The issue is really moot, so we're not going to deal with it at all. Instead, what we're going to do is we're going to vacate the portion of the opinion that deals with the Fourth Amendment issue, the interrogation at school, and we're going to save that for a later day on a different case when it's right. So the outfall of all that is that the Ninth Circuit's decision in Green v. Camreta that relates to, they covered a whole bunch of other things, including judicial deception, fabrication, all that stuff in sections, I think it's 2B and C. But what the Supreme Court did with regard to Section A, that's the Fourth Amendment claims, they vacated the decision, so it's no longer binding or controlling authority. What's happening, though, is the general consensus is, and it's on both sides of the aisle. If you talk to the county attorneys publicly, they'll tell you, oh, no, we still get to do it. If you talk to the school district attorneys, they've all formulated policies in writing that say, unless they have a warrant, you shouldn't let them talk to the kid because we may get sued. So the school district attorneys are reading Camreta a little bit differently than the counties are, and we're on our side, the plaintiff's side, we see Green v. Camreta even more differently than the counties do. In our view, at least in the Ninth Circuit, the next case that makes it up is likely, the Ninth Circuit's likely to do the same thing they did on Green v. Camreta. And that is to say that a child being interrogated by social workers at school without the presence of a parent or even the knowledge of a parent and without a warrant is going to require a warrant. Probably that's going to be tempered against some sort of time requirement. For example, if a social worker goes out for 10 minutes and does sort of a short, non-aggressive, non-hostile interview with a principal or school official there, my guess is that's probably going to be okay with the courts. But it's when they get into these invasive, intensive, aggressive interrogation techniques with a child at school, you know, that's going longer than 10 or 20 minutes, something like that. Those are probably going to require a warrant to be held unlawful. So we just have to wait and see where the law develops in that area. Let's just do 2 more and then let's move on. Yeah.
So do we go to the Ninth Circuit Court only, or do other courts also open, from LA, California, do we all just go to Ninth Circuit? Is that the destination?
All right, just so everybody has the question, it related to venue. The question was, where do we file these cases, right? Is it going to be federal court or state court? Essentially, is that the question?
Isn't there a, Ninth Circuit is just...
That's an appellate court. You don't get to the appellate court until you've made it through a trial court. So I'm interpreting your question as meaning...
You keep saying Ninth Circuit?
Okay, let me explain that first. Okay, when we're filing one of these cases, the law that we're dealing with is going to be federal law. Remember, this is a constitutional violation. The United States Constitution, the law that is going to govern the way our rights are treated in a lawsuit or our lawsuit's going to be treated, is going to be under federal law. Now, that's not to say that you can't file your case in state court, and that's not to say that state opinions, published appellate opinions, might not also influence the outcome. But it's going to be federal law that applies. In deciding where to file your case, whether it's in state court or federal court, that involves a whole different analysis. You have to look at the venue that you're going into, look at the history of the judges, look at the appellate history of that specific district, see how they generally treat your type of case. If they don't like your cases and they keep affirming dismissals, different venues. You know, what we do, for example, in San Diego, that's a good example. Now, we only file those things in federal court. San Diego state courts, they're very, at least so far in our experience, they've been very pro-government. Very, very difficult to litigate one of these cases, so we'll only file in federal court.
When you say federal, you mean Ninth Circuit?
No, Ninth Circuit's an appellate court.
Okay. When you say, what court is that?
A federal district court.
Yeah. You're going to file it. The federal district courts are the trial courts. The Ninth Circuit's the appellate court. So if you lose in the trial court, you'll go up to the Ninth Circuit. The Ninth Circuit is the one that controls our area in California. Their decisions are binding on California courts with regard to federal claims.
She's asking, what court do you appeal from to the Ninth Circuit, the federal district court?
Okay. I guess I was getting the question wrong just for the video and everybody else. The question was, what can you say?
The Ninth Circuit Court.
How do you get to the Ninth Circuit?
Okay. The only way you're ever going to get to the Ninth Circuit Court of Appeals is if you filed your case in a federal district trial court. Does that answer?
Okay, and how do,
So which court in LA would that be?
It would be the one down on Royal. It'd be the district court in LA.
Spring Street.
No, Spring Street. No, to get to the second district court of appeal, that's a state court of appeal. To get a case in front of the second district court of appeal, you would file your case in state court. Okay. One more, and then we're moving. Go ahead.
require a warrant to interrogate a 4.5-year child at Stewart House, so-called forensic interview with no audio, no video, when you have double mirror.
Okay, wait. What's the question?
My question is, if he exists, Miranda rights when somebody is detained. When a child is detained, detention, where is the child's right to have represented by an attorney or a third party to be present when being interrogated by a social worker?
Okay. Let me make sure, I'm going to interpret your question again, and let me know if I've got it right. Does a child have a right under the Fourth Amendment to some sort of Miranda disclosure or something like that?
Interview with no audio and video by a so-called child.
Okay, no audio and video doesn't matter, it doesn't even factor into the question. The question has to be, does a child have a right to not be interviewed or interrogated by a social worker without a warrant?
And attorney present, or third-party present.
Okay, that's not the law. They're not entitled, as a matter of constitutional law, okay, to have third-party presence or an attorney present or something like that when they're interviewed. The inquiry is going to be, do they have parental consent? And or is there an emergency? If there is no parental consent and there is no emergency, you can have God present, and they still need a warrant. Okay, does that answer the question?
Parental consent, when you go to a house which you don't know what happened behind, we go call Stewart House in Santa Monica.
Okay, let's do this, because this is getting a lot more detailed. Do it next break.